Yeah, you know what time it is. Disclaimer: I am not an attorney, nor do I offer or give legal advice. So please understand that all information that we talk about in any of my webinars are strictly information and educational purposes. And most of it is just personal experiences with things anyway. So please understand this is not legal advice. And may you be blessed on your journey to find your power within these laws. Peace and blessings. Now we're going to look at the third document in relationship to a mortgage. This is the promissory note. And this is on Investopedia. Promissory note, what it is, different types, pros and cons. What is a promissory note? A promissory note is a debt instrument that contains a written promise by one party, the note's issuer or maker. This is also known as the payor, to pay another party, the note's payee, a definite sum of money, either on demand or at a specified future date. A promissory note typically contains all the terms pertaining to the indebtedness, such as the principal amount, interest rate, maturity date, date and place of issuance, and the issuer's signature. Although financial institutions may issue them, for instance, you might be required to sign a promissory note in order to take out a small personal loan. Promissory notes usually allow companies and individuals to get financing from a source other than a bank. This source can be an individual or a company willing to carry the note and provide the financing under the agreed upon terms. In effect, promissory notes can enable anyone to be a lender. Okay? Pretty good information right there. Let's scroll down, see the key takeaways. Pretty much what we just already said. All right. How promissory notes work. Promissory notes, as well as bills of exchange. Let's click on that. Bills of exchange. When you click on these hyperlinks, someone's going to load. Click on it again. Is it going to load? Bills of exchange definition, examples, and how they work. Bills of exchange is written orders used primarily in the international trade that binds one party to pay a fixed sum of money to another party on demand or at a predetermined date. Bills of exchange are similar to checks and promissory notes. They can be drawn by individual or banks and are generally transferable by endorsements. Endorsements. We're going to come back to that one. All right. So, promissory notes, as well as bills of exchange, which is what we just covered, are governed by the 1930 Geneva Convention of Uniform Law on Bills of Exchange and Promissory Notes. Its rules also stipulate that the term promissory note should be inserted in the body of the instrument and should contain an unconditional promise to pay. In terms of their legal enforceability, promissory notes lie somewhere between the informality of an IOU and the rigidity of a loan contract. A promissory note includes a specific promise to pay and the steps required to do so, like the repayment schedule, while an IOU merely acknowledges that a debt exists and the amount one party owes another. A loan contract, on the other hand, usually states the lender's right to recourse, such as foreclosure, in the event of default by the borrower. Such provisions are generally absent in a promissory note. While the paper might make note of the consequences of non-payment or untimely payments, such as late fees, it does not usually explain methods of recourse if the issuer does not pay on time. Promissory notes that are unconditional and sellable become negotiable instruments that are extensively used in business transactions in numerous countries. Let's click on negotiable instruments, shall we? All right, let's go to negotiable instruments. All right. What is a negotiable instrument? A negotiable instrument is a signed document that promises a sum of payment to a specified person or the assignee. In other words, it's a formalized type of IOU. So, what are we talking about? Negotiable instruments. What were we talking about before that? Promissory notes. These promissory notes are a form of a negotiable instrument, which is also formalized in the type of a IOU. Okay? A transferable signed document that promises to pay the bearer a sum of money at a future date or on demand. The payee, who is the person receiving the payment, must be named or otherwise indicated on the instrument because they are transferable and assignable. Some negotiable instruments may trade on a secondary market. All right, and we're gonna go ahead and bounce back. But you see how when we start looking at these definitions, they build on each other. All right. Now let's see, where were we at here? Negotiable instruments. All right. So now it's going to start talking about student loan promissory. No, we're not going to go into all of that. Let's look at the UCC on negotiable instruments now. Now we're at the UCC. This is 3-104 negotiable instruments, Universal Commercial Code, which has also been adopted by each state. So I strongly suggest you find your state statutes and codes that corresponds with these UCC statutes. All right, except as provided in subsection C and D. C, which is an order, that means that D is a promise and order. Okay, cool. Negotiable instrument means an unconditional promise or order to pay a fixed amount of money with or without interest or other charges described in the promise or order. If it, 1, is payable to the bearer or to order at the time it is issued or first come into the possession of a holder. 2, a payee on demand or at a definite time. And 3, does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money. Now, if you see one of my previous videos, I think it was titled Accord and Satisfaction, I spoke on restrictive endorsements. Well, this is the language that they're referring to in this negotiable instrument. Okay? But the promise or order may contain I, an undertaking or power to give, maintain, or protect collateral to secure payment. 2, an authorization or power to the holder to confess judgment or realize on a dispose of collateral. Or 3, a waiver of the benefit of any law intended for the advantage or protection of an obligor. All right. Instrument. Instrument means negotiable instruments. It's also C, an order that meets all of the requirements of subsection A, except paragraph 1, and others fell within the definition of check. In subsection F is a negotiable instrument and a check. A promise or order other than a check is not an instrument if at the time it is issued or first comes into possession of a holder, it contains a conspicuous statement. Conspicuous statement. However expressed, to the extent that the promise or order is not negotiable or is not an instrument governed by this article. An instrument is a note if it is a promise, and a draft if it's an order. An instrument is a note if it's a promise, and it's a draft if it's an order. Are we paying attention? Awesome. If an instrument falls within the definition of both note and a draft, a person entitled to enforce the instrument may treat it as either. We in these definitions, check means a draft. Other than a documentary draft payable on demand and drawn on a bank or a cashier's check, a teller's check. An instrument may be a check even though it is described on its face by another term. such as money order. Cashier's check means a draft. Okay, teller's check means a draft. Traveler's check means any instrument that is payable on demand. So we learned this in terms of what? Negotiable instruments. All right, so now that we got a better understanding and background on what negotiable instruments is, which the promissory note falls into that category, right? Let's look at a promissory note in action. And now I had reached out to the lender and asked them to send me a copy of the note that they have so that I can, view it for its authenticity. And this is what they sent. Send me a document, see they have a copy, certified true copy. Now understand, people, this doesn't mean anything at all, okay? This is just a tactic to intimidate somebody. Alright, if you scroll down through here, you see the date on this document. You see the amount, $244,000, lender, all that good information, that monthly payment, the address where they want you to send payment to. Here goes the maturity date, the first date the payment's supposed to begin, or it's supposed to be due on every month. Borrower's right to repay, loan charges, all this good information, right? You got a little signature over here, initial, give a notice, blah, 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 uniform, secured note. Then we get to the signatures right here. You see me, okay, they have the all caps name with a signature there, all caps name. Now you notice something that's not on this document, right? Outside of the all caps name signatures right here, this document is not notarized. Okay? It's not notarized. So what does that mean? The other documents are all notarized, right? So there was a notary present that verified that whoever this all caps name is, right, was there to sign. So think about that for a second. They're sending you a document alleging that this secures their interest and alleging that you signed it, but there's no proof that anybody outside of whoever was here signed this or was actually physically present on this date. Alright? And this is 2 of 3. So if we keep scrolling down this document, let's see what else is at the end. Oh, what is that? Okay, this is the last page, 3 of 3. It says, pay to the order of without recourse. Bayshore mortgage funded. Wow. Buy, and then whatever this scribble scrabble is. Right? They're running around enforcing a document like this, or trying to enforce a document like this. Ask yourself, what other types of documents do you see this type of language on? Pay to the order of. We thought this was a promissory note, a promise to pay. Well, with this language, they took this document and endorsed it and created an order. What did the definition say an order to pay is? A draft or a check. They turned this document into a check. So wouldn't it be logical to think that they got paid? I don't know. That's something you might want to think about. They got paid with a document that wasn't even authenticated or certified of its authenticity, right? Because no notary was present. So ask yourself, do you think they can enforce this? I beg to differ. Think about that for a little bit. We'll pick back up. So I already have pulled up here. Let's look at the note that's actually recorded in the county records. Wait, did I say recorded in the county records? Yes, I said recorded in the county records. Why? Because they were supposed to record the note, but since they didn't, I went on and did it for them. Why? Because it's my document and I have the power to do that, and they were supposed to do that. So since they didn't, that's technically a breach of contract. but we'll get to that later. But here we go. So here's the note. As you see, it's an unofficial copy. You can see we're on the Dallas County website. And let's go. Okay, page 1. Page 2. Same language as before. Page 3, there's something different under that signature. What do we have here? We have an acknowledgement of a third party bearing witness to the parties being present and involved on this document. You have the all caps name here as the borrowers, and then you have the notary signature, and then you have this endorsement of acceptance signature, which is actually the settler. All right. Yes, so we have an actual recorded note. But guess what? This serves as evidence that the obligation has been fulfilled. So now ask yourself, the document prior did we show that had the what? Endorsement on the back of it where it was cashed? Now, which one do you think is going to be more enforceable? Something that does not have an authentic signature that was witnessed by a third party? Or a document that could easily be forged and claimed to be an original? Or how did they label it, as a certified copy? I guess you could say checkmate. Let's take a look at this quick video.
In 1969, there was a Minnesota court case involving a man named Jerome Daly, who was challenging the foreclosure of his home by the bank which provided the loan to purchase it. His argument was that the mortgage contract required both parties, being he and the bank, each put up a legitimate form of property for the exchange. In legal language, this is called consideration. Mr. Daly explained that the money was, in fact, not the property of the bank, for it was created out of nothing as soon as the loan agreement was signed. Remember what modern money mechanics stated about loans? What they do when they make loans is to accept promissory notes in exchange for credits. Reserves are unchanged by the loan transactions, but deposit credits constitute new additions to the total deposits of the banking system. In other words, the money doesn't come out of their existing assets. The bank is simply inventing it, putting up nothing of its own, except for a theoretical liability on paper. As the court case progressed, the bank's president, Mr. Morgan, took the stand, and in the judge's personal memorandum, he recalled that the plaintiff, bank's president, admitted that, in combination with the Federal Reserve Bank, did create the money and credit upon its books by bookkeeping entry. The money and credit first came into existence when they created it. Mr. Morgan admitted that no United States law or statute existed which gave him the right to do this. A lawful consideration must exist and be tendered to support the note. The jury found that there was no lawful consideration, and I agree. He also poetically added, only God can create something of value out of nothing. And upon this revelation, the court rejected the bank's claim for foreclosure, and Daly kept his home. The implications of this court decision are immense. For every time you borrow money from a bank, whether it is a mortgage loan or a credit card charge, the money given to you is not only counterfeit, it is an illegitimate form of consideration, and hence voids the contract to repay, for the bank never had the money as property to begin with. Unfortunately, such legal realizations are suppressed and ignored, and the game of perpetual wealth transfer and perpetual debt continues.
All right, now I hope this information has been beneficial thus far, as well as the video that you just seen. I hope it shed even more light on the situation so you can get a better understanding on just how deep and serious this situation you may be in involved with these mortgages. Now, there is ways to undo what these people have done to you, but first we must gain a great understanding of who we are and what we can do, which is our power in each one of these documents. And if you need a little bit of assistance, feel free to reach out to me and schedule a consultation. Peace and prosperity.